Hi everyone, welcome from Law with Dunk the Law Guy, and today is day 30 of the Case Today series journey, covering cases across criminal law, tort law, contract law and the English legal system. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. Also, as you can see, I'm looking a bit different today and I look different as I'm really happy. We climbed above 200 Instagram followers over the bank holiday weekend, and so I'm taking this as an opportunity to unlock a new Law Guy character. Being completely serious with you all though, it really does mean a lot when you're supported by not only current students but former students that I taught years ago. And it's really nice to be able to see my former students living such happy lives and chronicling their happiness on Instagram. So that's always nice to see. Again, I just wanted to say a big thank you. Genuinely, it feels like this might be the start of a law community that I always wanted this to become. And we're now less than 100 Instagram followers away from unlocking me looking silly as the Hulk Hogan inspired Dunk Dogan. I do cringe a bit just saying it, but I'm committed now. Plus, it's the only opportunity I'll ever have to wear a beard. Anyway, today I'd like to go over Green v DPP 1996, which could be a low priority case. I've included it in one of my criminal law handouts just so my students can appreciate another example of how a statute can impose a duty upon a defendant to act, and where they fail to act, their omission can form the actus reus of a criminal offence. To whoever goes on to watch this, you may have been taught it by your teacher. In Green v DPP 1996, the defendant owned a strong Staffordshire Bull Terrier dog. He'd left his dog chained up in his back garden, however the dog managed to break free from its chain and went on to bite the face of a young child in a nearby garden. The defendant was found guilty of allowing his dog to enter a place it was not allowed to be, in which it went on to cause injury, which is a criminal offence under Section 3, subsection 3 of the Dangerous Dogs Act 1991. The Divisional Court held that this offence could be committed via an omission. In this case, the defendant failed to take proper precautions as the chain and enclosure weren't good enough. Here you can see the defendant failed to take proper precautions, which was his omission, but owed a statutory duty under Section 3, subsection 3 of the Dangerous Dogs Act 1991, and this failure to act amounted to the actus reus of a criminal offence. And that's it for today. Thank you from Law with Dunk the Law Guy, and I'll see you tomorrow.